Welcome back. Today, we're skipping the usual pleasantries and dropping right into the high-stakes action of a defining moment in Philippine legal history. We're looking at the 2003 Oakwood Mutiny, specifically through the lens of the landmark case of Gonzales versus Abaya G.R. number 164007, which the Supreme Court decided on August 10, 2006. Now, this isn't just a story about a military standoff, it's a fascinating, deeply complex exploration of where lines are drawn when the fundamental powers of the state collide.
Think about this for a second. When an armed soldier threatens the state, are they acting as a rebellious citizen or a disobedient soldier, right? It's not just some philosophical riddle. It's the core constitutional tension of our entire explainer today. Because the answer to that question determines who gets to put them in handcuffs, who gets to put them on trial, and ultimately, what system of justice decides their fate.
Section 1. The Oakwood Mutiny.
Okay, let's dive into this and set the scene. To understand the legal puzzle, we're traveling back to the summer of 2003. The regular hum of the nation's capital was suddenly interrupted by a very real, heavily armed crisis, and things moved incredibly fast. On July 26, 2003, President Gloria Macapagal Arroyo received these alarming intelligence reports. Some members of the armed forces of the Philippines, carrying high-powered weapons, had completely abandoned their designated posts. Their reported aim? Nothing short of destabilizing the government. Within hours of this crisis unfolding, the president issued a direct order to the AFP and the Philippine National Police to track down and arrest these rogue soldiers.
So picture this massive confrontation. On one side, you have junior officers like Lieutenant Eugene Gonzales, Lieutenant Antonio Trillanes IV, and several other AFP members who took over the Oakwood Premier Apartments in Makati. On the other side, representing the institution, is General Narciso Abaya, the Chief of Staff of the Armed Forces. Now, this physical standoff was eventually resolved, but it immediately birthed a massive legal showdown that would have to be settled in the highest court of the land.
Part 2. Who tries the soldiers?
All right, so the soldiers were apprehended. But that is where our legal mystery truly begins. Now that the mutineers are caught, who actually has the constitutional power to put them on trial? Do they go to a regular civilian court like any other person who breaks the law? Or do they face a military court-martial? To unravel this, we have to go back to the very foundation of criminal law. Based on Bouvier's Law Dictionary, which our legal sources cite, a crime is simply an act committed or omitted in violation of a public law forbidding or commanding it. When these soldiers abandoned their posts with weapons, they were absolutely committing acts forbidden by law. But the real question is, which law?
Now, what's really interesting here is the state's inherent authority. Under its police power, the state has the inherent authority to define and punish crimes. This is just a natural attribute of a sovereign power tasked with defending the community, right? But the state actually has two entirely different toolkits for doing this when it comes to military personnel.
On the one hand, we have civilian penal laws, like the Revised Penal Code. These are laws of general application. They apply to everyone in the Philippines, and their goal is to protect the general public and maintain social order. But on the other hand, we have the Military Articles of War. This is a strict, parallel universe of law designed solely for members of the armed forces to ensure discipline, obedience, and the chain of command. So when a soldier mutinies, they are potentially violating both systems at the exact same time.
Section 3. The RA 7055 Doctrine.
This brings us to the crucial legal mechanism that resolves this whole overlap. In Gonzales v. Abaya, the Supreme Court relied heavily on a specific law that acts kind of like a traffic cop for this jurisdictional intersection. I absolutely love this quote from the Case Digest because it beautifully bridges the two worlds of justice we just talked about. It reads, "Members of the armed forces are generally subject to civilian penal laws, but RA No. 7055 preserves court-martial jurisdiction over service-connected offenses specifically defined in the enumerated Articles of War." In short, soldiers are citizens first and are subject to civilian courts except for a very specific category of crimes.
Part 4. Service-connected offenses.
Let's move to this and see how it builds. What exactly qualifies as a service-connected offense? This is literally the fulcrum upon which the entire Oakwood Mutiny case balanced. The mechanics are fascinating. A military offense, like disrespecting a superior or going AWOL, is strictly prosecuted by a court-martial. But here is where it gets complex. A single rebellious act can be related to a civilian criminal charge, like rebellion or sedition, while simultaneously triggering an independent military charge. As long as the military charge is independently service-connected, as defined by the specific Articles of War, the military court retains its jurisdiction over that specific infraction, even if civilian courts are handling the broader criminal charges.
But hold on, we can't forget the absolute baseline here. Under Section 14, Paragraph 1 of the Bill of Rights, regardless of whether a soldier is standing in front of a civilian judge or a military court-martial, overarching constitutional rights always apply. No person shall be held to answer for a criminal offense without due process of law. Both systems of justice are strictly bound by the Constitution, they just serve different state interests.
Section 5. The final verdict. So the crucial point is, taking all this constitutional theory, the definitions of crime, the state's police power, and the doctrine of RA 7055, how did the Supreme Court actually resolve the petition filed by Lieutenant Gonzales against General Abaya? Well, the court ruled that the military court absolutely retains jurisdiction to handle the service-connected infractions committed by the mutineers under the Articles of War. The civilian courts could try them for the civilian crimes of rebellion or coup d'état, for sure, but the military must be allowed to police its own ranks for strictly military offenses. The court brilliantly unknotted the jurisdictional tug-of-war, ensuring that military discipline is preserved right alongside the supremacy of civilian laws.
Which leaves us with this final, kind of provocative thought to ponder on our last slide. In the delicate balance of a nation's security, where exactly does military discipline end and civilian justice begin? The Gonzales v. Abaya case shows us that the line isn't always a solid, impenetrable wall. Sometimes it's a careful, overlapping boundary designed to protect both the state from its enemies and the state from its own defenders. Thank you for joining me for this explainer, and keep questioning the structures that shape our world.